Good afternoon, everybody. I'm Aaron Dunn. I'm an attorney in the litigation department here at Beresford Booth, and I'm going to be talking to you today about motions to compel discovery. Why? A couple of reasons. Number one, past webinars have focused on the discovery process in general and the process by which parties get information from the other side and certain motions. But I wanted to bring those two concepts together and talk about a motion that comes up from time to time in civil litigation, and that is a motion to compel discovery. The other reason is because in today's day and age, everybody wants everything quickly. They want it now. You come to find out in civil litigation, it doesn't happen quite that way. Sometimes you have to be patient, and ultimately, sometimes you have to get the court involved to resolve issues, and those can include discovery issues. And that's what a motion to compel is all about. So, what is a motion to compel discovery? It's a motion brought under Civil Rule 37 that asks the court to compel another party to comply with their obligations under the civil rules and provide discoverable information and or documents. So basically, it's a motion of last resort. And why do I mean last resort? I mean that because for motions to compel, they're not heard like other motions. Courts will not hear them unless the parties have conferred about the motion, talked about the motion before filing. So, in other words, you can't just go out and file a motion to compel without providing notice to the other party. You have to tell the other party what your issues are with the discovery at issue, and then seek the court's involvement if you can't reach a resolution with the other party. So, what kinds of discovery are generally the subject of a motion to compel? Well, generally, we're talking about Civil Rules 33 and 34, which are interrogatories and requests for production. Again, discovery is the way that parties get information from the other side. You don't just file a lawsuit, get to trial, and say, aha, gotcha. Have you ever seen this document? Typically, you get to get information from the other side via the discovery process. Civil Rule 33 authorizes a party to serve interrogatories on another party. Interrogatories is just a fancy way of saying written questions. You can think about who, what, when, where, why, how. Tell me about your claim damages. Tell me about your claim defenses, etc. Then we have requests for production, which are authorized under Civil Rule 34. You can ask the other party to give you documents, which is broadly defined, including writings, drawings, graphs, charts, photographs, etc. So you can ask the other party, hey, give me documents that are relevant or potentially relevant to the case as long as they're not privileged. Also notably, Civil Rule 34 authorizes requests to permit entry onto designated land to do things like take photographs, survey, inspect, etc. So we're really talking about interrogatories and requests for production. So why would a party file a motion to compel discovery? Well, or when would a party file a motion to compel discovery? Well, after the time for responses have become due. Generally speaking, parties have 30 days to respond to discovery requests, to issue answers to interrogatories and responses to requests for production. Generally, there are extensions that are granted. A party says, I know I have 30 days, but I need an extra 2 weeks. I need an extra month. Generally speaking, those types of extensions, at least the first one, are granted. So we're really talking about 30 plus days after you serve discovery requests on another party. And as you see on the screen, it's after conferring with the other party. That's when you would file a motion to compel. Again, this goes back to courts do not just hear motions to compel as they do other motions like motions to amend, motions for summary judgment. You need to confer with the other side before you bring a motion to compel discovery. So the progression goes something like this. A lawsuit's filed, the plaintiff files a complaint, says defendant is liable under various theories. The defendant sometimes answers the complaint, maybe asserts affirmative defenses, maybe counterclaims. And after the complaint is filed, or even sometimes along with the complaint, a party serves discovery requests on another party. Again, this slide is showing, is intending to show anyway, interrogatories and requests for production. Again, interrogatories are the when, where, why, what, how, and then requests for production. Give me your documents. Then you wait the 30 plus days for responses. That can be a painful process sometimes because, again, everybody wants everything right now, but you do have to wait the allotted time, 30 days at least. And then if you still haven't received responses, or the responses that you received you have issues with, you either write a letter to the other party, that's typical, or you get on the phone with the other party. You definitely are going to have to get on the phone with the other party at some point and say, hey, your responses are deficient for X, Y, and Z reasons. I need the responses. I need supplemental responses within 7 to 10 days, 7 to 14 days, something like that. Give it to me. Give it to me now. Give it to me within a reasonable time period, or I'm going to the court and asking the court to compel responses. So why would a party file a motion to compel discovery? Well, we're really talking about two different types of issues. Number one is the no response motion to compel. Hey, the other side didn't respond. I need the information. They haven't responded. Court, compel them to give me responses, to give responses to me in a timely manner. And then you have the not good enough motion to compel. You say they responded, but their answers are deficient in some way. So let's break those down. We have the no response motion to compel. This is a fairly simple process. You waited the allotted time, you waited 30 plus days after you served discovery requests, and the other side still hasn't responded. You talked to the other attorney, you said, hey, I still don't have responses. Give them to me within the next 7 days, or I'm going to the court and asking them to compel responses. They don't do so, so you file your motion. You tell the court, hey, we served discovery requests on September 1st. It's now November 4th, and we still don't have answers. I talked with the other attorney. I requested responses by a date certain. They haven't done so. Compel them to produce documents and respond to my interrogatories. And then you hope for an award of attorney's fees. As we'll get to later in this presentation, attorney's fees can be granted in connection with a motion to compel, but they're not guaranteed. Never tell clients to bank on an award of attorney's fees, even if you are successful in a motion to compel. So that's the simple motion to compel, no response. Then we have the not good enough motion to compel. Whatever they did, sure, they responded, but it's not adequate. So this can be broken down into two subcategories. Number one would be they responded to some of my discovery requests, but not all of them. They answered interrogatories 1 through 10, but left 11 through 25 unanswered. They responded to requests for production A through F, but left the rest unresponded to. You can ask the court using that same process that we just discussed. Hey, they responded to some, but not these others. Compel the other side to respond to all of my discovery requests. Then we have the most complicated is the insufficient response motion to compel. Sure, the other side responded, but you think it's deficient in some way. They answered the question, but maybe in a manner that's not complete, or you think is evasive. As an example, you ask for contact information for everybody with knowledge of the claims and defenses at issue, a fairly standard interrogatory. The other side just provides names, no contact information, no addresses, no phone numbers, incomplete. Or you ask the other side for, hey, I want to know what are your damages? And the other side says, yeah, we've been damaged. Is that evasive? Is that incomplete? Probably. It's a facts and circumstances analysis, but there are certain situations where an answer is evasive or it is incomplete, and the other side has an obligation to fully respond. Another subcategory within this subcategory is the production is limited. They responded to requests for production, but what they produced appears limited. For example, they produced a bunch of emails between January and April. And then there's a big break until July, but some emails in July reference emails between May and June, but those May and June emails were not produced. You say, I think that's incomplete. They haven't fully responded. I'm going to bring a motion to compel to force them to give me all the responsive documents, not just some. And then the final kind of subcategory is hiding behind an unsubstantiated claim of privilege. Sometimes parties will say, in response to an interrogatory or a request for production, hey, what you're asking for that involves privileged information, attorney-client information, work product. There's some type of privilege that allows me as the responding party not to give you what you're asking for. Sometimes the claims of privilege are not substantiated. You ask for, again, individuals with knowledge. They say that's privileged information. You say, I don't think so. I'm going to ask the court to say that's not a substantiated claim of privilege, and the other party, the responding party, is required to fully respond. So that's the not good enough motion to compel. It's the most complicated, takes the most amount of attorney time because you have to explain to the court why the answers are incomplete, evasive, claim of privilege does not apply. You're often going to be before a judge who has read nothing other than the motion to compel, the response, the reply, and perhaps the pleadings, the complaint and the answer. They're not going to come in with enough knowledge to know the intricacies of the case. So you're going to have to explain to the court why the answers are incomplete, which is a difficult thing to do in certain cases. So let's talk about a hypothetical. It's very generalized and probably overgeneralized, but hopefully gets the point across to see how a motion to compel can arise in practice. So let's think about a case where we have a plaintiff buyer who alleges that the defendant seller failed to disclose material defects related to a property that was just purchased, including basement flooding and foundation issues. The plaintiff buyer maybe gets wind from a neighbor that, oh yeah, the defendant seller, the prior owner, they had contractors there all the time. I heard they had a flood, but none of that was disclosed in the course of the sale. So the buyer serves interrogatories, or the plaintiff serves interrogatories on the seller, asking about repairs, renovations, contractors the defendant seller may have hired in the past while they own the property. Along with those interrogatories, the plaintiff buyer serves requests for production that ask the seller to produce documents related to repairs, renovations, contractors they hired or retained, etc. For this hypothetical, imagine that the defendant seller responds to the interrogatories by saying, yeah, we did renovations. Yeah, we had some repairs done. Yeah, we hired contractors, but that's it. They don't expand as the request asks them to do. And then with document production, they produce some photos that are not dated. It's hard to tell where they're from, when they were taken, at what time period during the home ownership, and they provide a receipt for a contract or maybe a check that says $500 from 2 years ago, but you have no idea what that relates to, and they didn't produce any other documentation. In that type of situation, again, very generalized, typically the plaintiff's attorney would write a letter to the defendant's attorney saying, hey, I know you responded to our discovery requests, but I think what you provided was inadequate. Here's the reasons for that. You provided photos, but they're not dated. You said that there were repairs and renovations performed. When were those performed? By who? Who were the contractors that your clients hired? I need to know that information. I'm entitled to that information. And then they set up the CR26I conference. That's the meet and confer requirement conference before filing a motion to compel. So they get on the phone and the plaintiff's attorney says, look, I'll give you another week. I'll give you another 2 weeks to respond to the discovery request to supplement your responses. And if you don't, we're going to file a motion to compel. 2 weeks goes by and the defendant still hasn't supplemented. Maybe the plaintiff gives them another couple days, says, all right, hopefully it's coming in these next couple days, but it doesn't. In that situation, should the plaintiff move to compel responses? Probably, because additional information may establish the plaintiff's claims. If there were renovations done that related to the foundation, related to basement flooding, and then that's disclosed, that and that wasn't disclosed during the sale, but it's disclosed in discovery, that could establish the plaintiff's claims. Additionally, document production, an invoice from a contractor, or text message from a contractor saying, "Hey, you have substantial foundation issues. You don't want this flood to occur again. You need to fix this." Yet the plaintiff or the defendant seller rather still didn't disclose that during the course of the sale and denies that they had any knowledge of the basement flooding issues or the foundation issues. That document provides great valuable information, impeachment material for the plaintiff to put up, and says, defendant, I know you said you didn't have any knowledge, but this is you on this email, right? This is you on this invoice, correct? Yes. So you get the point that discovery can be very valuable, and by moving to compel responses, you can get information that's very helpful to the claims at issue. But there are practical considerations. It sounds good in theory, and when I'm talking about practical considerations, I'm talking about oftentimes clients say, "Hey, we're going to get our answers right now. If they haven't responded within 30 days, you're going to move to compel. We're going to get them to respond. We're going to get the court to intervene." And that's where attorneys oftentimes have conversations with clients and say, "Well, it sounds that simple, but it's really not." And the reasons for that are there are multiple reasons for that. And one of them is courts really do not want to get involved in discovery issues. Courts are busy hearing dispositive motions, arraignments, better issues to deal with than discovery issues. They don't want to get involved and say, are the parties really complying with their obligations? Are they getting along? Courts don't want to do that. So you may be frustrating the court, to put it lightly, if you bring a motion to compel on day 32 after discovery responses become due. Another consideration is you can't bank on an award of attorney's fees. Like I mentioned, clients sometimes think, "Hey, if we win, we're going to get attorney's fees," right? Not necessarily. So you got to think about how much time and money it's going to take to bring that motion to compel, to potentially have it granted and then not have the attorney fee award, so it's sunk cost. Another practical consideration is, what stage is the litigation in? Are we 9 months out from trial? Is there additional time for us to get this information? Do we really need it right now? Or are we going to look somewhat like tattletales if we go to the court and say, "Hey, they haven't responded, even though we're 9 months out from trial, I need it right now"? Does that look great? Maybe not in every circumstance. Are there other ways to obtain the information you're seeking? Now, I'm not excusing any party's failure to comply with their discovery obligations, but as I'll explain in a later slide, it looks a lot better if you're going to bring a motion to compel and you say, "Hey, the other side said they didn't have this, but we subpoenaed a contractor and they provided 100 pages of documents, yet the defendant's saying they have no documents related to that contractor." That's going to look better before a court and say, "Hey, the defendant's really not complying with their obligations. There's substantial evidence of that. Maybe I will award attorney's fees to the moving party." So there are practical considerations before you just bring a motion to compel. I don't think it's smart for anybody to just fire off a motion to compel, on day 35. Discovery responses are issued 35 days later. They didn't comply, or we think their answers are not good enough. Go file a motion to compel. I don't think that's a great strategy in every scenario. Certainly, there are scenarios where that may be a good strategy, but not in every case. So we've talked about a motion to compel. Let's talk about avoiding one as the party responding to discovery. Obviously, you don't want to get in the situation where you're faced with a motion to compel. You're told, or the other party accuses you of not complying with your discovery obligations, and you potentially have to pay the other side's attorney's fees if the motion to compel is successful. So how do you avoid it? Well, when in doubt, produce documents in your possession, custody, and control. It stinks to have to go through all your documents, see what's responsive to discovery requests. You think this has no possible relevance to the case. Well, what you think is relevant may not align with what other party thinks is relevant. You don't make that determination as the client or even as the attorney necessarily. So I'm always in favor of overproducing. Of course, unless a privilege applies or it's clearly not relevant. But in a close call, when in doubt, produce the documents that you have in your possession, custody, and control that are responsive to the request. Another thing to keep in mind is to take the time to answer discovery thoroughly and truthfully. Every case has warts, no doubt about it. I hear parties all the time talk about, well, this is going to look really bad if the other side sees it. I'm yet to see the perfect case. I'm yet to see a case without warts. What's really going to look bad is if you're forced to go, if you're compelled to produce that document that you're scared about and are hit with sanctions for not disclosing it originally. So take the time, go through the documents, go through the requests, answer them thoroughly, answer them truthfully. That will go a long way to avoiding the motion to compel. And finally, be reasonable. I think that can be the overarching theme of discovery disputes is be reasonable with the other side. Of course, everybody wants the information that they think they're entitled to. In reality, is everything as important as an attorney or a party makes it out to be? No. But just being reasonable with the other side can go a long ways. So I know there are emotions at stake in litigation, but the more you can look like the more reasonable party, the better off generally you're going to be in the motion to compel context. So now talking about building a successful motion to compel as the party who wants to move for one. Number one, you need to thoroughly evaluate the discovery responses and production. Again, we're in the not good enough motion to compel category. This is a collaborative process between the client and the attorney. Oftentimes, the client is as acquainted or even better acquainted with the facts than the attorney is, who's more focused on the legal aspects. Sometimes a client will get the discovery responses from another party in the production and say, well, I think this is missing. I don't think they actually fully responded to this interrogatory, or I don't think they produced all their documents for X, Y, and Z reasons. That's why it's really important to have a collaborative process between attorney and client when you're reviewing another party's discovery responses and production. Another tip is to be reasonable but firm with the other side. Again, back to reasonableness, it goes a long way. If the other side says they need another 14 days to respond to discovery and you're gung-ho and say only 7 days will do, that doesn't look very reasonable. Being reasonable goes a long way before a court. But there is a time to draw a line in the sand. If the other side says, I'll get you supplemental production, but I can't guarantee any date certain, well, that doesn't provide any finality for your client, doesn't move the case along necessarily. So drawing a line in the sand, it has to happen at some point. Another tip is to try and obtain responsive information through other parties or non-parties to establish that the responding party to the discovery is not complying with their obligations. This goes back to something I mentioned a couple of minutes ago. It looks a lot better in a motion to compel if you've gone through other means to try to get the information that you think you're entitled to from the responding party. For example, if in the hypothetical that we were talking about, you can subpoena the contractor if you know their name and say, give me all your documents related to any repairs, renovations, whatever you did at this property. And if they come back with information, with documents, and yet the other side, the responding party to discovery says, we don't have any documents with that related to that contractor. Obviously, it doesn't look good for them. So try to obtain as much as you can through other means to build your motion and compel to tell the court, hey, they're saying that they don't have information. They clearly do. Compel them to fully respond. And then I think probably the best tip is to document issues with other parties' discovery responses. This goes back to when you get responses that you think are deficient, it's a really good idea to have that collaborative conversation with your attorney and have the attorney write a letter to the other side's attorney to say, here's why we believe your answers are deficient, why your document production is deficient. Don't just say they're deficient, explain why. And that way you can show the court as an exhibit in your motion to compel. Court, I told them last month that these are the issues with their discovery responses, yet they still haven't fixed those issues. They've had plenty of time to do so. There's no excuse for their actions. So not only compel responses, but also award us our attorney's fees. That goes a long way, as opposed to just saying, hey, we had a conversation approximately 4 weeks ago on the phone. It looks a lot better if you have it in writing. So let's talk about what are some advantages to a motion to compel. Well, you typically get the other party's attention. They have to respond to the motion, so you're certainly going to get their attention if you haven't already. And obviously, you can get information and documents from another party that you otherwise would not have obtained. That can be very helpful to your case. Discovery is very valuable, and a motion to compel can prove very valuable if you get documents that establish your claims or establish your defenses that you otherwise would not have obtained because you're dealing with a party who doesn't want to comply with their obligations. And then finally, another huge advantage to a motion to compel, if it's successful, is a potential but not guaranteed attorney fee award. Um, Under Civil Rule 37, the court shall, after an opportunity for a hearing, award the moving party their attorney's fees unless the court finds that the opposition to the motion to compel was substantially justified or that other circumstances make an award of expenses unjust. So the court has an out route. They can say, even though I'm granting this, I think the response was substantially justified, or there are other reasons why an attorney fee award it's not reasonable in this matter. So you can get attorney's fees, but by no means guaranteed. What are some of the main disadvantages to a motion to compel? Well, this goes back to involving the court is a risky proposition. They don't want to deal with discovery disputes, and if you do get them involved, there's a chance that they're annoyed. Um, Along those same lines, it may become moot. The motion to compel may become moot if the other party adequately responds before the motion is set to be heard. So let me explain this. Sometimes the gung ho party says it's day 35, and after the discovery requests were issued, and I still don't have responses. The other side says, yeah, I need 2 more weeks. The moving party says, not good enough. I'm going to file a motion to compel. It's heard, 9 days later, and by the time it's set to be heard by the court, the responding party has adequately complied with the discovery requests. So you go before the court and you say, the responding party says, Your Honor, there is no dispute here. We've already responded to this. This is a moot issue. And the moving party says, well, it would not have been necessary unless but for the fact that the responding party failed to comply timely. Or it may say, there is no real dispute. Moving party, you have what you want. Goodbye. That's a real disadvantage to moving to compel discovery too quickly. It is, in my opinion, more advantageous to be patient, again, but firm, and really build your motion to compel in a manner that does not invite a valid, reasonable response that, hey, we complied, albeit not quite timely, in a reasonable time manner. Another disadvantage is the time and money. Again, you could be sunk costs. You could spend thousands of dollars on a motion to compel, even if successful, that you don't get the smoking gun that you were hoping for, or you only get documentation that actually does not support your claims. Motions to compel take attorney time, no doubt about it, especially in the not good enough category. The attorney can write a 10-page brief and a 5-page response brief, and he can ultimately yield no real results in terms of advancing your case. So time and money is a disadvantage to a motion to compel. Another disadvantage is a motion to compel can prompt a motion for a protective order and or a successful opposition. Protection order is a motion brought by a responding party to discovery, essentially saying, hey, the moving party's overreaching. They're asking for information that's privileged beyond the scope of discovery or combination thereof. They're essentially being too aggressive. They're asking for too much. And with a protection order, they can say, or not only should you deny the motion to compel, you should grant a protection order saying that the moving party is no longer allowed to inquire into these topics. They've gone too far already. They're no longer allowed to do so. And if a motion to compel is unsuccessful, there is authority under Civil Rule 37 that says the responding party is entitled to their attorney's fees or can be entitled to their attorney's fees. It's not a de facto yes, but it's a possible. So it's important to consider, are you actually overreaching? Are you actually moving to compel, not for a litigation tactic, but for valid reasons that you really need the information? So there are disadvantages to a motion to compel that you should carefully consider with your attorney before you greenlight the motion. So some key takeaways from motions to compel. Consider the costs and potential benefits of a motion before filing. Don't just run out and file a motion thinking that a court's going to grant your motion and award you attorney's fees. It's not always going to be the case. Attorney's fees, again, are not guaranteed. They can be granted, but in practice, are they granted often? I wouldn't say often. So keep that in mind when you're considering telling your attorney, go out and file a motion to compel because we're going to get our fees. There's a chance you won't. And then finally, another key takeaway, consider exhausting other methods of obtaining the information you want before filing a motion to compel. Again, this kind of goes back to be reasonable. Are there other ways you can get this information? Have you deposed the party who's responding to discovery? Have you asked family members, friends, other witnesses that could yield helpful information to at least bolster your motion to compel? At least consider that before filing a motion to compel. It's not necessarily required, but I think it's good practice. So if you have any questions, feel free to contact me. My contact information is on the screen. The lawyers at Beresford Booth have a lot of experience in litigation, dealing with and resolving discovery issues. So whatever your litigation needs, feel free to reach out. Thank you. Have a good day.